Welcome to Our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, this is John Roberti. Welcome to the show. Our topic today is the basics of merger review. Can we have mergers without tears? When we hear about antitrust in the news, we're often hearing about mergers. And when we talk about mergers within the antitrust section, we often talk about them in terms of complicated ideas. Today, we want to have a conversation with an expert on mergers to try to demystify that and explains how the antitrust agencies evaluate mergers. My co-host today is Sergei Zaslavsky. Hi, Sergei.
Hello, John.
What do you have lined up today?
We're going to focus on mergers. Oftentimes when antitrust lawyers talk about mergers, it's all HHI and SNP and all this jargon, and people's eyes just glaze over. We're going to try to cut through that and explain to our audience what a merger review is really all about.
Who's our guest today?
We are very lucky to have with us Mike Keeley, who is one of the most knowledgeable practitioners on the subject of mergers. Mike is a partner at the Axon firm and is the co-chair of the Antitrust Section's Mergers Committee. And
what are you hoping to get out of the conversation today, Sergei?
Sure. So oftentimes you hear people talk about antitrust and mergers in the media, and it's all very high level. Should we have more enforcement? Should we have less enforcement? And we are going to try to really zero in on the key fundamental questions that will actually help people understand how merger review works. Why are some mergers a concern and others aren't? What tools do lawyers and economists use to actually figure out whether a merger is a potential concern or not? And how does the merger make its way through the clearance process? So we're going to demystify that hopefully today and try to have a little fun in the process.
All right, great. Well, let's bring in our guest. Mike Keeley, welcome to the program.
Thanks, John. Sergei, thanks a lot for having me.
Absolutely. How are you doing today, Mike?
I'm doing great. It's fantastic to be on Our Curious Amalgam.
Terrific. So when you talk to somebody who's not an antitrust lawyer about the merger clearance process, let's say you're talking to a business person at a client, how do you explain the process without getting into all the lawyerly jargon?
Well, first of all, you're assuming I talk to people who aren't antitrust lawyers, which is a big leap, but fair enough. So when I deal with a client, it's actually pretty simple. The first question you should always ask your client is, why do you want to acquire your competitor? And that tells you almost everything that you need to know. Now, that might make it seem too simple, so I'd like to at least pretend that we bring something else to the table as well. But often the answer is something really good, like I want to acquire my competitor because we're two of 15 companies in the space, and if we come together, we can be more efficient, and they do something that I don't do, and I do something that they don't do, and together, it's like that old commercial with the Reese's peanut butter cups. Walking down the street, the chocolate bar crashes into the peanut butter jar, and they realize they've invented this great thing together they didn't have before, the Reese's peanut butter cup. So I use that example sometimes with clients, and the older ones understand what I'm talking about. But sometimes the answer is a little bit different, and often clients are honest about it. I want to acquire my competitor because that SOB is killing me on price. He's undercutting me. He's taking all of our clients, and I want to put a stop to it.
Not the answer you want to hear.
Well, it certainly ensures a long antitrust review at the agencies. So, occasionally the answer comes out. Unfortunately, sometimes the answer is, I want to do this for all of these efficient reasons. And then when you get into the client's documents and emails and records that they created as part of the process, it says, I want to take out this SOB because they're killing me on price. And so part of the task is is trying to come to the right answer, and then bringing that answer to the agency and saying, look, this may seem like a merger of two competitors, and we can understand why you might have some concerns about this. Maybe it's the FTC or the Antitrust Division, but here's all the really good reasons for this merger that are going to be good for consumers, and they're going to help this company be more efficient, more competitive, and in the end, drive a better outcome for customers.
And I'm sure sometimes you have a situation where they want to do it for all the right reasons, but it's not 15 competitors. It's 4 competitors. They want to do it for the right reasons, but it's susceptible to the interpretation that there might be some problems with the merger. And those are the tough cases, right? Where each side kind of a plausible argument going for it.
Well, Sergei, you said 4, and I always think 4 is sort of the magic zone on mergers and acquisitions. I think most people would say if a merger is going to result in 3, it's probably going to have some trouble. And if it's going to result in 5, most people are going to say it's okay under most circumstances. And 4 is kind of the battleground, to oversimplify the scenario. And so we'll look at 2 things. And again, going back to how do we talk to clients? Well, the first principle is after your merger, how many competitors are going to be left? And if that number is really high, you're in the clear. If it's really low, then you have to do some more work. And so sometimes it's just, is this a 5-4? We'll say, I don't think that's too jargony for this. Or is it a 6-5? Or is it a 3-2? And depending on that lower end of the band, the harder the merger is going to be to get through. And so we do things like count number of competitors. We calculate market shares, which is just a fancy way of saying, what percentage of the sales in a market do the companies together represent. And, the higher the market share, the more likely it is to cause problems, and the lower, the less likely it is to cause problems. There's a bunch of other tests that we can work with economists to get through, but that's the basics of it. And then there are some exceptions. So you have to remind clients that just because you have a lot of competitors doesn't mean that there's definitely no problems, because some competitors matter more than others. So if you have, say, 10 competitors, but 2 of them are just always going at each other, they're always the most potent competitors, they're the ones who end up in the last round of the bidding, and the other 8 always fall away, well, then the merger of those 2 competitors is more likely to raise issues.
Now, you're talking about number of competitors and market shares. Does the issue ever come up, well, what market are you talking about? Where are you measuring shares? And if that does come up, how do you advise a client on figuring out what the right market is?
Yeah, this is actually the best part of my job, is trying to understand who's in the relevant market. And I'm sure our listeners know that terminology no matter what part of antitrust or consumer protection that they're involved in. But it's a pretty basic test, and it starts with Supreme Court law around reasonable interchangeability and, which products really compete with one another. And there's lots of ways to try to get into that. One of them is to say, well, let's look at the actual real world and see whether customers are switching back and forth between different products. I've done some supermarket mergers in my day, and it's one of my favorite examples to use with clients no matter which field they're in, because everyone knows what a supermarket is. Everyone goes shopping. And so when you look at supermarkets, you focus on who competes with supermarkets. The FTC has always been the one who reviews supermarket mergers from time immemorial. And the FTC for many years, and still to some extent today, believes that supermarkets compete with supermarkets. And even though you can buy food and grocery items and other places, those types of stores don't belong in the same market as a regular supermarket. And so sometimes the battle is to say, well, why doesn't a 7-Eleven, which sells a bag of coffee, compete with the supermarket? And there's lots of ways to get into analyzing whether or not customers are really going back and forth between the 7-Eleven and the supermarket, and whether they really constrain each other in the marketplace so that they should count. But that's just one example.
So what kind of tests would you actually consider to answer that question? Is 7-Eleven in the same market as a supermarket or not?
Well, this is where economists often get involved, so I don't like to talk about it because we lawyers like to keep the turf to ourselves. But we have a lot of economists out there, including my co-chair, Joanna Chai, who's a great asset to our committee as our economist members. I had to make that disclosure so I don't get in trouble back at the farm. Scanner data can be really helpful to looking at what prices do at a supermarket, and whether The prices at a supermarket over time have changed based on maybe the new development of a 7-Eleven down the corner from the supermarket. Did the 7-Eleven come in and did the supermarket freak out and say, we got to lower prices? There's a 7-Eleven in the neighborhood now. Odds are they didn't. And so a 7-Eleven probably not in the same market. But if a supermarket is in business and a Target superstore opens down the street, I bet the supermarket freaks out and says, you know what, we need to be really careful. Otherwise, we're going to see our sales go down when this Target superstore opens because they're selling all the same groceries we are, or most of them.
Got it. So it's the freak out test for market definition. If you freak out about somebody, then they're a competitor and they're in the market.
No jargon, right, Sergei? No jargon. It's a freak out test.
So, Mike, you talked a little bit earlier about raising an eyebrow. Let's say if you find there's a big market share, right? Lots and lots of sales within a relevant market, and so when that happens with a client that I'm trying to help, I typically will tell folks I'm working with there has to be one of two things going on here. Either you have the wrong market, and that's what we've been talking about, or market share doesn't matter.
Absolutely. And so market share doesn't matter is one of those places you never want to end up in dealing with the transaction. but sometimes you do go there. To build on that, sometimes it doesn't matter because sometimes maybe there's one player that's been out there for a long time and maybe they had the field to themselves for 20 years. But if you look at the last year, 3 or 4 players have come onto the field, and if you look in the last year, the market share is just measuring that period may look a lot different, and that's the trend. So one of my favorite things about mergers, and this might suggest a lack of accountability, but I don't mean it that way, is it's almost like a crystal ball exercise. This is the one area of antitrust where you really are looking to the future, and you're trying to predict what's going to happen. And so you do your best. And sometimes the way to predict what's going to happen is to look at the recent past as opposed to the ancient past. And the Supreme Court has helped us with some cases over the years that guide us in the way. Just not to focus on process too much, but back in the 60s and 70s, before we had the HSR Act, the Hart-Scott-Rodino Act, companies didn't seek permission. They didn't file a notification with the government before they did a merger. They would just do it. And then it was on the DOJ or the FTC to rush into court the next week and seek an injunction to hold the companies off while they could bring a lawsuit. But the HSR Act put into place this waiting period. So now we file, we notify, we talk to the DOJ and the FTC about what the deal's about. We give them information and data. And we work together to try to persuade them that the future looks pro-competitive and the future does not look anti-competitive. But because of this HSR Act, that's why we're the one area that gets to look. We're like forecasting. It's like the weatherman on the 6 o'clock news, predicting what the weather's going to be a week from now. Hopefully, our percentages of accuracy are better than the weatherman, but not necessarily.
So that's interesting. You're saying market shares is just one thing to look at, but what you're ultimately trying to get at is the competitive effects of a merger. What kind of competitive effects are the agencies usually concerned about?
Sure. So there's 2 types, and I'll try to get past the jargon really quickly. The first one is called coordinated effects, and this is the idea that if you have a small enough number of competitors, people will compete less aggressively because they will know that if they are a little bit less aggressive on price, then the chances are that their competitors will be less aggressive as well. They don't have to be worried that there's 15 Yahoos out there who one of them's always going to go bananas on and price low. There was an example. The FTC brought a case some years ago, which they ended up losing, but it was called Arch Coal, and the argument was that one coal mining company was acquiring another, and as a result, there were going to be such a small amount of coal producers in this region of the country that they would all sort of agree to dig less coal. Now, the FTC lost that in district court because the judge concluded, no, there's enough, and there's no really evidence that this is going to be a problem going forward. The other is called unilateral effects. And we talked earlier about, whether some competitors matter more than others. And, that's an example of that. And we talked about supermarkets back in the late 2000s. Whole Foods, which everyone knows, tried to acquire its rival Wild Oats. And both of those were supermarkets, but they were sort of high-end natural, organic supermarkets. And there, the Court of Appeals ultimately found that Whole Foods and Wild Oats were closer together than other supermarkets. So your A&P, your Giant, your Safeway, they didn't matter as much because they weren't competing in the same niche as Whole Foods and Wild Oats. And so that's why that deal got blocked.
Excellent. So now let's say a supermarket, a client of yours comes to you and says, hey, we want to acquire our competitor. You go through the questions we talked about. You determine they're doing it for the right reasons. The marriage should go forward. You're there to help them. What's the actual process? Where do you go from there?
Sure. So assuming that it's a pretty straightforward merger, the first step is getting ready to prepare your Hart-Scott-Rodino form, and that's a notification form that contains financial information, information about ownership structure of the company, and using government codes determining whether or not the two merging companies do the same thing. So that's a horizontal overlap, a head-to-head overlap. You file that with the FTC and the DOJ, and they have 30 days, with some exceptions, to look at it and say, this seems like something we should look at more deeply, or just to give it a pass. If they give it a pass, they'll let the 30 days run out, or they'll grant something called early termination, sorry for the jargon, which allows the deal to then close. If they have more questions, they can issue what's called a second request, which means asking the parties to produce lots of data and documents and submit for interviews and depositions. There's a lot of middle ground there that practitioners use to try to avoid getting into a second request because they're really expensive and they take a long time. So we will often engage with the government either before we file the Hart-Scott-Rodino form or right after to say, hey, we understand you may have some questions about this. Here are the answers. The government during that period often will reach out to customers, the company's top customers, to ask them what they think about the deal and to kick the tires on the arguments that we're making to the government during that period.
And let's say you do get into a second request situation. How does that end? What happens when the second request period runs out?
Yeah, so by the end of the investigation, the FTC or the DOJ will have come to a view as to whether or not they still have concerns. In some deals, they reach the end and they say, okay, we've kicked the tires, we get it, no problem. And they close the investigation and the deal can close. In some cases, they say, we hate your deal. Your deal will never be approved, and we will sue you in district court if we have to keep you from closing because we think it's just awful. And then you end up in district court, and you have a litigation in front of a judge who then decides whether or not the deal is okay. And then the middle place, which happens a lot, is the government says, look, we have some concerns with your deal. Let's say we're doing supermarkets again. We say, you have a lot of competition, but on Staten Island, in an example that was close to my heart about 10, 12 years ago, you're buying the only competing supermarkets there are. It's an island. We'd love to approve most of your transaction, but Staten Island has to be fixed. And then you do something called the divestiture, and it's done according to a consent decree, which is something that gets filed with the court. And in the divestiture, you say, okay, I'm going to take these stores in Staten Island. I'm not going to buy them. I'm going to instead enter into a contract with somebody else who operates supermarkets, and they're going to buy them. And they'll remain as competitors to me after the deal closes.
Well, that's very informative, Mike, and really helps us understand the process. So we've talked about supermarkets, about horizontal merger where you acquire a competitor. Are there other kinds of mergers that sometimes attract attention?
There are, and there's been a lot in the news lately that we call vertical mergers. This is where a company is acquiring its supplier or a company is supplying its distributor. Think of AT&T Time Warner that was litigated last year. In those transactions, they're almost always pro-competitive and they almost always get cleared easily. But in some cases, the government gets concerned that the acquiring company will take the control over its supplier or its distributor and keep it all to itself and not let its competitors use that supplier or that distributor anymore. And that will have a negative impact on the marketplace. So it's a foreclosure theory. So that's another type. And then, of course, there's something called conglomerate or everything else. If you think about supermarkets again, where you may recall when Amazon acquired Whole Foods, there was a big political uprise about how could Amazon buy Whole Foods? Amazon is this dominant company, and Whole Foods has my favorite kale. And it actually got a look from the FTC. But, Amazon is an online retailer, and Whole Foods, while it has some online retail, is a high-end grocery store. And in the end, they didn't really compete, but there were some concerns about that.
So antitrust kind of has enjoyed a resurgence in the popular news in the media recently. It's been a hot topic. Could you give us a couple subjects on mergers specifically that have been a subject of discussion among commentators recently?
Well, I think the most interesting things going on right now are the role of the courts in dealing with mergers. In the CVS-Aetna transaction, the DOJ took a consent decree and agreed to approve the transaction with some limitations, but Judge Leon decided he was going to have some hearings in Washington about whether to approve that, and that raises all sorts of interesting issues around the role of the judiciary in reviewing basically prosecutorial discretion on the behalf of the executive branch. So I thought that was quite interesting. And then the other area I think has been a big focus has been this vertical area where companies are really trying to figure out where is the government going. It's been a little bit unpredictable lately as to what the enforcement policy will be towards vertical mergers. Some people have been pushing the government to issue guidelines around vertical mergers, but there's been a lot of resistance on the government's part to do that.
Mike, obviously, you love practicing antitrust law. You love practicing merger law. Why is that? What is it about practicing antitrust that's fun for you?
Well, I like to think of it as really, a continuing Master's in Business Administration, MBA. When we are working for a client, it's often on the most important thing that's happening for a company at the time. And certainly from a legal perspective, they're trying to make a big strategic acquisition. And as a result, usually the instructions come down from the CEO. If Mike calls with a question as to, how this business works or how to understand this document you wrote 4 years ago, that's your first priority. And so I know a lot of us lawyers struggle to make sure that, we're serving our clients well, and sometimes clients have a lot of competing obligations. It's nice to be at the top of the list. Also, I just think, going from industry to industry over the years has been phenomenal, all the way from, not just supermarkets, but funeral homes and video games and, computer search engines. It's just it's really an intellectual feast.
That's great. Now we just want maybe to let our listeners know a little bit more about you. So tell us something surprising or unusual about yourself.
Surprising or unusual about myself? Surprising. Well, my true favorite topic when I'm not practicing antitrust law is cooking at home. I cook for the family on the weekends, and I can't say I'm great at it, but it's something I really enjoy.
So what's your go-to?
Well, it depends who I'm cooking for, but my daughter, who's 14 and will kill me if she ever hears this, which she probably won't, to be honest.
That's not the goal. That's the goal. But go ahead.
She and I, we make pasta together. So homemade pasta from scratch, and she's a big fan of pesto. So
very, very impressive. Okay, well, and now we hit the last segment of our show, which is called The Curious Hat.
And now it's time for The Curious Hat.
Okay, Mike, the Curious Hat, I have a hat, and inside the hat are a group of index cards with questions on them. You choose the card, and I'll ask you the question, and then I get to ask you a follow-up question as well.
Okay, can I just say that the hat has two eyes, one of which is missing the eyeball?
Yeah, that's why it's curious. It's a little bit of a troubled hat today. Okay, this is a good question, Mike, because we've been talking about food. So the question for you is, what is the best restaurant you've tried in the past year?
The best restaurant I've tried in the last year is Fiala Mare in Washington. It's Italian seafood right by the Georgetown waterfront. Phenomenal. If you're in D.C., I highly recommend you try it, but make a reservation in advance.
What do we order?
Anything that resembles like a cioppino for me is a go-to. So a seafood stew. The menu changes a lot, but it is tremendous.
Okay, and now our follow-up question. Similar question. What is the best restaurant you've tried in the last year that serves either chicken nuggets or hot dogs?
Oh boy, chicken nuggets or hot dogs. Well, I have 4 kids, and so let's say chicken nuggets or hot dogs are go-to food.
It's pretty much every restaurant I've been to in the last year as well.
So I think that, again, keeping it local, Z Burger on Wisconsin Avenue in Tenleytown is amazing.
Very strong choice. Well, Mike, thank you for coming. That's it for our show. We hope you enjoyed it. We will be back next week with our next episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by the ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent those of their employer or other organization. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. If you have suggestions for topics or are interested in participating in a future episode, please reach out to us at ourcuriousamalgam@americanbar.org. Until next time, thank you for listening.